When someone dies without a will in New York, no one will be permitted to take charge of the property or the bank accounts that belong to the person who passed away unless they first get a court order giving them permission to do that. And in order to get that court order, somebody will have to go to the Surrogates court, which is the special court that deals with death and the property of people who have passed away, and apply for an order that appoints them as the administrator of the person's property and money. This action that's brought before the Surrogates court happens in two ways. It's either done on consent, where everyone who is entitled to learn about this action signs off on a piece of paper and says, I don't have any problem with John Doe or the person's mother or wife being the administrator, and everyone signs what's a piece of paper called a waiver, and the court enters the order. But when you can't get everyone to sign that waiver, what happens is a hearing is scheduled before the court, and everyone who has the right to participate and appear gets a notification of that hearing, and if they want to fight the request to be the administrator, they have to appear in court and fight it. The reason why I wanted to talk to you about that is because it can be annoying and time-consuming to get all the information we need when we don't have the consent of all family members and the court is going to have a hearing. The Surrogates court is a special court that protects people who can no longer speak for themselves. It's also a court that has had to face a lot of fraud and abuse, because you can imagine what happens to people with money and property when they can no longer take care of themselves. Sometimes they're very ill. And so the court is very diligent and very careful to make sure that any person that might be entitled to participate in sharing property of the person who passed away knows about this court hearing and has the opportunity to come and appear before the court hearing. The court will require the person applying to be administrator to prove that they know who the family members are that are entitled to receive notice of this hearing, and that they have notified these people. Where it can be difficult for all of us when we're preparing the cases is that sometimes we don't know who all the family members are, or we don't have all the contact information that we need from them so we can satisfy the court. So we ask you for your patience in this regard, because the more information we can produce on our own to prove to the court that our information is correct, the faster and quicker the process will go. If the court is not convinced that we don't have all of the people we need to have that have been notified, the court may require us to hire an investigator to make sure that we have listed all family members, that we know who all family members are. And that is an expense that really nobody wants to pay for. So our request from you for names, addresses, family members, and phone numbers is really important to us. And we ask you for your patience, but we do it because it's better for your case. Thank you.